Assalamu alaikum. Hello. Now we will begin the second part of our inaugural session. In the first part, we had a very robust conversation on the legal system in Pakistan and the views that the very diverse views held within the bars in Pakistan. And now we'll use that to segue to the second part of our conversation, in which is Pakistan's international human rights obligations. Uh, Pakistan is bound by international treaties. Pakistan has ratified a lot of the major human rights treaties. Pakistan's compliance with those treaties, both through laws and practice, is something that we hope to inspect, to discuss, uh, to interrogate over the course of the next 2 days. And we're very privileged to have with us esteemed international speakers, UN Special Rapporteurs, ambassadors, partners who are key allies in the fight for human rights in Pakistan. And I'll begin by calling His Excellency Mr. Raimundas Karoblis, who's the ambassador of the European Union to Pakistan, to come and speak.
Terrorist act which took place yesterday in Islamabad. Condolences to victims, families of victims, to all Pakistani people, and wishing speedy recovery for those who are wounded. We, European Union, and in general, all civilized world does not accept terrorism in any forms. It's horrible crime, and everybody which are related with that should be brought to the responsibility. Coming back to this issue, indeed, so it's great honor to be here to participate in Sulema Jahangir conference. The importance of the conference cannot be overstated. It is one of few spaces which gives voice to a wide spectrum of views and backgrounds. At the heart of every democracy is the assurance that individuals can express themselves with a view to upholding their rights and those of others. The European Union is proud to have supported this conference since the very beginning. We are widely represented by ambassadors of the European Union member states and member states' special envoys who came especially to participate in the conference. I congratulate AGHS, the Supreme Court Bar Association, and the Pakistan Bar Council for organizing this conference. I would like to start off honoring the legacy of Sulema Jahangir. As Pakistan's leading human rights lawyer, she showed incredible courage in defending the most vulnerable: women, children, religious minorities, and the poor. In a world of turmoil, Sulema Jahangir serves as the inspiration. We need resilient human rights defenders, including lawyers, to support victims. We also need democratic and inclusive institutions that leave no one behind and seek to prevent violations, and courts that protect citizens in case violation nonetheless happen. In this respect, I am honored to be the first international speaker after the keynote intervention of leading actors of the legal fraternity in Pakistan. Your vision and commitment must be praised. As we have observed in some recent judgments, the independence of judges and lawyers, and their role in upholding the progressive rights enshrined in the Constitution of Pakistan are key to ensure enjoyment of human rights by all citizens. Impartial and fair judicial decisions are crucial to sustain an environment where human rights defenders and lawyers can support victims. We also need law enforcement agencies that adhere to human rights standards, are accountable and efficiently investigate crimes, notably those affecting the most vulnerable, such as crimes against women or minorities. Relying on courts and the law is also one of two strategies adopted by the European Union to guarantee respect for fundamental rights by its own member states. All European member states are part of the European Convention of Human Rights, and its courts renders mandatory discussions that uphold adherence to human rights through the Union. The second strategy is, of course, the adherence to international norms and systems guaranteeing human rights, in particular by the United Nations. Telling the European Union has starting to adhere as a regional entity to treaties such as the Convention of the Rights of Persons with Disabilities, meaning such treaties do not only bind the European Union member states, but also the European Union institutions. The European Union spares no efforts to defend the multilateral order. In the current context, this is more important than ever, and the European Union has taken unequivocal stances. It has, for instance, reaffirmed last November the importance of all states to fully engage with the Universal Periodic Review. I am humbled that several leading United Nations special rapporteurs could join us. Your role is essential, and it goes far beyond monitoring countries' adherence to international standards. United Nations special rapporteurs plays a very constructive role. They explain how norms can be operationalized in the face of new challenges. They share good practices and actively support states in meeting their international commitments. I therefore hope that you and other United Special Procedures that request so will be invited by Pakistan for official country visits. Like European Union member states, Pakistan had adhered to almost all international conventions, with only some treaties ratifications still missing. The ratification of the optional protocol to the Convention Against Torture and then Convention on Forced Disappearances would ensure a complete adherence to key international standards. United Nations human rights treaties, committees and procedures are not only crucial in and of themselves and for our respective countries and organizations also. They are also at the heart of the European Union-Pakistan relations through the GSP Plus system. GSP Plus is the European Union's autonomous trade concession to Pakistan. It is our way of helping Pakistan to boost its exports to the European Union single market by letting Pakistan sell its products on duty-free basis. The benefits of GSP Plus to Pakistan are huge. The European Union is far by #1 export destination for Pakistani products. Thanks to this program, Pakistan's exports to the European Union increased by 83% during a decade. In order to continue to have preferential access to the world's largest single market, Pakistan must demonstrate progress in implementing 27 United Nations core conventions on human rights, labor rights, governance, and environmental standards. And the European Union is obliged to monitor. In fact, a monitoring mission completed a visit to Pakistan early December last year. And I would like to thank very much the federal government, minister, provincial governments for the dialogue they have. Our colleagues saw some progress, notably through the adoption of the Anti-Torture Act, the reduction of the scope of the death penalty, or the adoption of Child Marriage Restraint Act for Balochistan and for Islamabad. Also bills regarding creation the commissions on minorities and journalists. They also saw lingering challenges, such as restrictions in the freedom of expression and media freedom, minority rights, and enforced disappearances, to mention just a few. I mentioned before that, but also several speakers before me, so the challenges related with human rights defenders and lawyers who defend that. Indeed, there are issues here. We can't close eyes. We can't be silent, and I expect that we will continue the dialogue on these issues with the government too. The GSP Plus mission report is being prepared as we speak, and Pakistan received some additional time to demonstrate progress, by the way, by the end of next week. To do so, Pakistan reviews by treaty bodies point to which actions could be taken. Just a few weeks ago, Pakistan was reviewed by the United Nations Committee on the Rights of the Child, which flagged essential measures that could easily be taken and would be go a long way transforming the lives of children, such as raising the age of marriage to 18 years old and criminalizing child marriage here in Punjab, a province that is more populated than any European Union member states, and where private companies benefit the most from the GSP Plus status. Therefore, now is the time for action. This report will be especially important as Pakistan will soon have to apply to be considered as the beneficiary country under the forthcoming new GSP regulation. It is important to note that the new GSP Plus regulation, applicable from 1st of January 2027, adds 6 new conventions on top of the existing 27. 2 of them, they are on human rights. And needless to say, the new regulation will deserve more rigorous implementation by beneficiary countries based on credible action plans agreed between the EU institutions and the government. And of course, equally strengthening monitoring from the European Union side. The European Union is not only addressing the issues of the progress, we are partnered to achieve our shared objectives to advance human rights. We are actively supporting Pakistan in meeting its international commitments through our development cooperation. Our Deliver Justice and Huquq Pakistan projects work hand in hand with the Ministry of Human Rights and justice system actors both federal and provincial level, to support human rights reforms and access to justice. We are proud supporter of the National Commission of Human Rights, which under the leadership of Ms. Rabia Javeri is played a vital role for human rights promotion and protection in Pakistan. Last but not least, we grant financial support to human rights projects carried out by civil society organizations, by our partners, to support victims and put forward solutions to very complex issues from child labor to climate change-induced human rights violations and others. Our support to Sulema Jahangir conference is part of such initiatives. Such a unique platform brings all key actors together to unpack issues and propose concrete and collective actions. I thank you very much for attention, and I'm sure that you will have very fruitful and constructive discussions. Thank you very much. Shukriya. Thank you.
Thank you, Ambassador. Our next speaker would be the Honorable Justice José Mateos, the Honorary President of the International Association of Judges and the President of the Appeal Courts of Porto, Portugal.
Thank you. Good morning to you all. This is a real challenge to speak before lunch, but we will try, me and my colleagues from the panel that I salute warmly. This is an honor to be here in this conference for many reasons. Of course, perhaps the most important reason is the person of Sulema Jahangir. I heard about her for many years. It's a reference not only for Pakistan, but all over the world. The struggles and the courage, the commitment to rule of law and to human rights from her is an example and a model for all of us. This is perhaps the most important thing that I will share with you, is my homage, my tribute to this wonderful person. So I will address you mostly as sharing my experience. Aristotle said that to communicate, to have a rhetorical argument, there are only three ways to communicate with people. The logos, that is through rational thinking. The pathos, that is the emotions that we share with the others. And the ethos, that is the origin of the word ethics. And the ethos is about the narrator, the credibility of the narrator, the experience of the person that is talking to you. I've been a judge for 36 years now. I work extensively on international expertise in 53 countries now. And that doesn't provide me any special knowledge, but for sure, it'll provide me experience. And the experience that I want to share with you, having witnessed in recent years the debacle of rule of law, the uprising of populist regimes, autocracies, and all the problems related with democracy fatigue, as some say. So 2 or 3 brief messages. The first is about international law, fundamental rights under international human rights law. When we speak about international law, and we have here several special rapporteurs, they will know, the first word is crisis. International law is in crisis. We live a very challenging time. The enforcement of international law is at risk. Everyone is talking about the future of international law, but let me bring you a positive approach. This is the name of the game, Crisis is the middle name of international law, and we must have this notion, historical notion, that it goes with the game. Progress in human rights is always a long struggle, and success is always mixed with setbacks. Despite this, we have a very positive legacy. If you look at what are the values, what are the main values for jurists, for law professors, for lawyers, for judges, during the history of our civilization, we can see that everything started with this idea of God. The law was at the service of a divinity of God. And you can see Inquisition, the Middle Ages, still in some countries is operating. Then we have the glorification and the empowerment of the prince. Machiavelli is a name that resonates to this idea of the law at the service of the prince. Then we have the French Revolution in our European culture, and then the idea of the people, liberté, égalité, fraternité, the idea of serving the people was the main issue for the law. And today, in present times, what is the alpha and omega of jurists, of lawyers, of judges, of law professors? Fundamental rights, human rights. So we can see in a global world that international law, fundamental rights, international law, is something that marks our main aspiration, our mission as jurists. And that is settled. That is settled since the 20th century, and we will continue in the future. The main challenge, and I will share with you a story that happens to me years ago in Bahrain. The main challenge is, what is the purpose of human rights law? I was in this conference, and this English professor bring two objects with him. One was a wooden duck. This wooden duck, a bibelot that we use in our houses. And the other one was a screwdriver. And talking to an audience like this one, he said that the main challenges for human rights defenders, for jurists that knows that our main principle is to defend human rights, is to avoid this idea of human rights as a wooden duck, as a bibelot. Nice words, nice proclamations, wonderful statements, and nothing happens the day after. No, we need to have human rights as a screwdriver, something that we will use in our daily routines as law professors, as human rights defenders, especially as judges. And when you are talking about screwdrivers as the main instrument for the defense of rule of law and human rights, we must think about the courts. The courts are perhaps the most interesting screwdriver that we had to uphold rule of law and human rights. So the courts are the bridge between international human rights standards and real protection for real people in their daily concrete lives. Some years ago in Poland, that faced a very difficult times, 2016, the crisis of the rule of law in Poland was very important for European Union. I was there for 8 times in a single year, trying to defend our colleagues, my colleagues, judges that were struggling with new laws, trying to break judicial independence. There was this international expert, a woman, that came to me and said, José, I work in international organization for 10 years on human rights department. But now I make a shift, I change my career. And I decided to work with in the rule of law department and to focus on the issues of judicial independence in the courts, to protect and defend the independence of judges. And you know why, José? Because if we have independent courts, it's the best way to protect human rights. It's the best way to protect fundamental rights. So we need to have a structure, and this applies to Poland, to Pakistan, to my country, to Europe, to Asia, whatever. We need to have a strong, solid structure that supports judicial impartiality and judicial independence. And the threats to the judicial independence are so many, but are always the same, regardless of the country, regardless of the region, regardless of the continent we are speaking of. Manipulated appointments, political driven discipline and strategic transfers shrink the rights and the space for adjudication. Appointment and disciplinary so-called reforms can quietly turn courts from human rights guardians into instruments of political convenience of those in charge at the moment. These are not technical details. They cut to the heart of courts' ability to protect human rights in a concrete and effective way, to be the screwdrivers that I talked before. So we need security of tenure, we need transparent and merit-based appointments, we need procedural guarantees that shield judges from retaliation, we need to have freedom of expression for judges when rule of law is at stake, when structural reforms are conditionating the work of the judges. At this regard, judges must be allowed to speak. I'm the president of the Consultative Council of European Judges, and we issued an opinion about freedom of expression of judges. And we issued in that opinion that judges have not only the right to speak, but the duty to speak. Each time judicial independence, rule of law is at stake. This was a quite pioneering approach to the freedom of expression within the judiciary, particularly within judges, but we felt that was the right time to issue that opinion around 3 years ago. So, going to an end, I will leave you with the last message. We judges are not experts with robes. We judges defend the equal right for any citizen. It's a very difficult job. We are always struggling with politics to try to, in a way, to repress our power and to make it a way for jeopardizing the checks and balances that are essential for any system. The best examples where judicial independence, when attacked, prevails, the best examples that we have in different regions and countries where the rule of law at the end prevails, were the countries where civil society was alert, were the countries where civil society was always there to defend not the judges, because judicial independence is not about judges, it's about common citizens, to treat everyone, especially minorities, especially those who are not in power, especially those who are facing opposition, that are opponents, especially these people need to have independent and impartial judges. So a conference like this one should be multiplied all over the country, all over the region, all over the world. A conference like this one, when one can openly speak and discuss what is needed to enhance the rule of law and to enhance judicial independence, is something mandatory for those who work on this field. I was speaking about Aristotle, about the ethos, the pathos, and the logos, and I will end again with Aristotle, because the Greeks, many centuries ago, they taught us everything. We just must repeat. Aristotle said, for men, when men are perfect, they are the best of all the animals on earth. But when they are separated from law, from justice, from these rules that I've been speaking about it, they can be the worst animals on earth. Thank you.
Thank you. Our next speaker is the United Nations Special Rapporteur on the Rights of Persons with Disabilities, Heba Hagrass.
Thank you, sir. First of all, I would like to start by apologizing for the people sitting at the back and cannot see me, but I assure you that you will be able to hear me loud and clear. Thank you. Excellencies, honorable judges, members of the legal profession, representatives of civil society, colleagues and friends. It is an honor to join you today at the opening of this important conference dedicated to the protection of fundamental rights and to the enduring legacy of Sulema Jahangir, whose life and work exemplifies principled resistance to injustice and the profound commitment to equality of law. As the United Nations Special Rapporteur on the Rights of Persons with Disabilities, I am particularly grateful for the opportunity to speak today on Pakistan's obligations under international human rights law with a focus on the rights of persons with disabilities. While my remarks are anchored in the context of Pakistan, they are equally reflective of the obligations borne by all states under the Convention of the Rights of Persons with Disabilities, or CRPD, a treaty that represents a paradigm shift in how disability is understood in law and in practice. The CRPD does not create new rights. Rather, it clarifies how existing human rights apply to persons with disabilities and sets out the concrete legal duties of states to ensure full and equal enjoyment. At its core, the Convention rejects charity-based or medicalized approaches to disability and replaces them with the right-based approach model grounded in dignity, autonomy, equality, and participation. Pakistan ratified the Convention in 2011 and is therefore legally bound to its provisions. Allow me to highlight several key dimensions of these obligations. First, the obligation of non-discrimination and equality. Article 5 in the Convention requires states to prohibit all discrimination on the basis of disability and to guarantee equal and effective legal protection. This obligation is immediate. It applies to both direct and indirect discrimination and extends to denial of reasonable accommodation, which the Convention explicitly recognizes as a form of discrimination. In practical terms, states must ensure that law, policies, judicial practices, and administrative procedures do not exclude or disadvantage persons with disabilities, whether in access to education, employment, healthcare, political participation, or justice itself. Equality under the CRPD is substantive, not merely formal. It requires provocative measures to dismantle structural and attitudinal barriers that have historically marginalized persons with disabilities. Second, the obligation to ensure accessibility as set out in Article 9. Accessibility is not an optional policy objective. It is a precondition for the exercise of rights. States must identify and eliminate obstacles to accessibility in physical environment, transportation, information, and communication, and services open to the public. Crucially, accessibility obligations are anticipatory. States are required not to be before execution occurs through enforceable standard monitoring mechanisms and effective remedies. Without accessibility, rights such as education, work, freedom of expression, and access to justice remain theoretically for millions of persons with disability unattainable. Third, the recognition of legal capacity on an equal basis with others enshrined in Article 12 of the Convention. This provision has profound implications for legal systems worldwide. It affirms that persons with disabilities are holders of rights and agents of their own lives, entitled to make decisions affecting them. States must move away from substitute decision-making regimes such as guardianship systems that remove legal agency and replace them with support decision-making frameworks that respect the will and preferences of the individual. This is practically relevant in areas such as poverty rights, consent to medical treatment, family laws, and access to courts. It was encouraged to see that in the ICT Rights of Persons with Disabilities Act of 2020, Pakistan recognizes the equality before the law of persons with disabilities and their legal capacity, even if they require support for their decision-making. I am eager to discuss with all of you how this is implemented and this provision is taking place in practice. Fourth, access to justice, addressed in Article 13, is of a particular relevance to this distinguished audience of judges and lawyers. States are obliged to ensure that persons with disabilities can participate effectively in all legal proceedings, whether as parties, witnesses, jurors, or professionals within the justice system. This requires procedure accommodations, accessible courts, infrastructure, training for judicial actors, and the elimination of laws and practices that undermine credibility or understanding on the basis of disability. Fifth, the obligation to adopt legislative, administrative, and budgetary measures. Article 4 of the CRPD makes it clear that states must align domestic laws with the Convention, repeal discriminatory legislation, and adopt comprehensive disability-inclusive policies. Importantly, obligations under the CRPD are not aspirational. They require resources, institutional coordination, and accountability. States must also meaningfully consult actively with persons with disability and their representative organizations in lawmaking and policy development. Participation is not symbolic. It is a legal requirement and a safeguard against exclusionary decision-making. Finally, international accountability and monitoring are central to the Convention's framework. States are obliged to establish independent national monitoring mechanisms, to report regularly to the Committee on the Rights of Persons with Disabilities, and to engage constructively with international and domestic scrutiny. Transparency and data collection, disaggregation by disability are essential to measuring progress and identifying gaps. In closing, let me emphasize that compliance with the CRPD is not merely a matter of treaty reporting or institutional reform. It is about transforming power relationships, redistributing opportunities, and affirming that persons with disabilities are equal participants in society and democracy. The protection of fundamental rights is indivisible. When the rights of persons with disabilities are weakened, the integrity of the entire human system is diminished. Conversely, when states take their obligation under the CRPD seriously, they strengthen the rule of law, social cohesion, and justice for all. I hope these discussions over the coming days will be important and we can discuss it together during the next coming days. Thank you all.
Thank you. Now I'll call upon the next speaker, who's the UN Special Rapporteur on the Violence Against Women and Girls, Special Rapporteur Reem Alsalem.
Assalamu alaikum. Distinguished ladies and gentlemen, first of all, I wish to extend my sincere gratitude to the organizers and to all the parties and partners who have organized this important and significant conference, and also to thank them for allowing me to be with you here today. This is actually my third time to be part of this magnificent conference, which has become one of the most important platforms for holding frank, principled, and human rights-centered discussions and dialogues on human rights, I would say not only in Pakistan, but really the continent. This would not have been possible if it were not for the efforts of particular civil society organizations, including women human rights defenders, including lawyers, including judges, and others, amongst them also victims, who continue to demonstrate really immense courage, intellectual rigor, and commitment to the human rights agenda, often exercised at immense personal risks. And I wish to take this opportunity to pay tribute to them. I've been invited today to address Pakistan's binding international human rights obligations. I'm going to, of course, focus on those obligations as far as they pertain to women and girls that are under Pakistan's jurisdiction. So that also includes non-Pakistani women and girls. And my remarks are going to be grounded really in the concerns that I and other independent experts have raised in recent years through communications and engagements with successive governments of Pakistan. Now, as many of you know, international law recognizes that women and girls are entitled to the full and equal enjoyment of all human rights and fundamental freedoms without discrimination, including without discrimination based on sex. And that is reflected in customary law, in international binding instruments, such as the Convention on the Elimination of All Forms of Discrimination Against Women and the two covenants. And Pakistan is, of course, a member to all these treaties and has ratified them. And international law also recognizes that women and girls should not have their rights violated, but not only that. In fact, states must also prevent very actively, punish and remedy such violations including those committed by private actors, and they must address structural discrimination that limits women's participation in all areas of life. It also requires states to adopt proactive measures to achieve substantive equality in law and in practice, including through the adoption of what we call temporary special measures to ensure structural equality. And as you know, they are a set of non-derogable fundamental human rights, meaning that states cannot derogate from these even under emergencies. And women, just like men, are also entitled to the full protection of their non-derogable rights, such as, for example, the right to life, freedom from torture, cruel and inhuman and degrading treatment, as well as freedom from slavery. Now, as I said, I'm going to briefly focus on the areas that we have engaged with the government of Pakistan on. And so the first, I would say, and I know my colleague Gina Romero is going to also speak to that at length, but I would say is the situation of women human rights defenders, particularly those working on enforced disappearance, minority rights, accountability. They continue to face harassment, travel restrictions, criminalization under counterterrorism and public order laws, smear campaigns, physical attacks, forced disappearance, and other reprisals. Another area of concern that has affected women and girls are blasphemy laws and related practices, which continue to expose women and girls, particularly, I would say, from religious minorities, to the risk of mob violence, prolonged detention, family violence, and challenges in access to legal and effective justice. Then we have the whole sphere of security and counterterrorism frameworks that are applicable, particularly in certain regions, I would say, such as Baluchistan, and that also have a disproportionate impact on women and girls. These have included enforced disappearances of them or their relatives, family members, harassment without the ability to seek justice, movement restrictions. They've also experienced internet disruptions and have experienced challenges in accessing education and services. And the application, of course, of this overly broad terrorism definitions have affected their ability to peacefully associate and to organize. I would say also that when it comes to non-Pakistani women, particularly women in need of international protection, particularly Afghan women also, they too must be protected and assisted against discrimination, exploitation, and violence, consistent not only with human rights law, but also refugee law. And it bears emphasis that international law doesn't permit selective protections. And for Afghan women in particular, I would say, and I know Richard will also speak to this, is that where it may appear that they have violated national laws, for example, if they are considered to have been responsible for or committed drug offenses, we have to really look at the power structure within their families. We have to see if they have been able really to make, to take decisions, to take free decisions, if they had information that they needed before we apply also punishments to them. And at any case, and in all circumstances, the principle of non-refoulement applies, which means that they cannot be returned to a place where their life would be in danger. A fifth area is the area of child early and forced marriage, which of course remains to be an area of concern. And here again, I want to say that girls, particularly belonging to religious minorities, are still at risk of forced conversions and forced marriage. And unfortunately, we know that the judiciary and law enforcement at times are complicit and pretend that the girls have done so also voluntarily. So under international human rights law, Pakistan, of course, has committed to prevent child marriage and protecting girls from harmful practices. And it has also taken important legislative and institutional steps towards the prevention and response to violence against women and girls, including also on preventing child marriages. And these are commendable efforts. They need to continue. I mentioned one of them, for example, recently, the Domestic Violence Prevention and Protection Act that was adopted in January 2026 and was enacted for the Islamabad Capital Territory. So all these efforts show that Pakistan is committed and can translate international standards into domestic legal solutions. Of course, the courts and the judiciary are important players in this. So I want to, for example, recognize that in 2025, the Supreme Court recognized psychological, verbal, and emotional abuse as cruelty and grounds for the dissolution of marriage through khula, strengthening legal protections against domestic abuse. Despite these achievements, I think all of us in the room acknowledge that challenges remain. Challenges such as the low reporting and conviction rate for perpetrators of violence, challenges such as continued survivor blaming attitudes, continued reliance on informal mediation in serious cases, and continued limited availability of shelters and services, referral pathways, particularly in rural areas. Now, I will close by reminding ourselves that experience tells us that the best laws on paper remain powerless, remain ineffective if there are not adequate resources to go with it to operationalize those legal and policy frameworks. So I would encourage the government and all Pakistani stakeholders to give teeth to their laws and institutions working on achieving gender equality by resourcing them adequately, and to invest more in education to change harmful social norms and gender stereotypes in line with Article 5 of the CEDAW that requires actually states to modify social and cultural patterns with a view to eliminating prejudices, customary and all forms of practices based on the inferiority or superiority of either males or females. Because violence is never a private matter, never culturally or religiously justified, and it is never inevitable. And fulfilling the international human rights obligations towards its women and girls is fulfilling obligations towards half of society. So that is not nice to have, that is not a luxury, but essential for the prosperity and development of Pakistan and its society. And with that, reassure you again of my continued support, and I'm sure also of my colleagues with me here today. Thank you.
Thank you. Our next speaker, the second last speaker of this session, is Richard Bennett, who's the UN Special Rapporteur on the situation of human rights in Afghanistan. So if I could request Richard.
Thank you, Saroop. Assalamu alaikum. I'm honored to be given the opportunity to speak on this panel alongside my special rapporteur colleagues at this important conference held in the spirit and legacy of Sulema Jahangir, who, among many other great achievements, was one of our most distinguished and inspiring predecessors. Since my mandate is human rights in Afghanistan, it's been suggested that I might address in this session on Pakistan's international human rights obligations the impact of Pakistan's policies on Afghanistan. This is a very complicated political subject, so I'll confine my remarks to an area where Pakistan's policies are affecting Afghans who reach out to me daily from Afghanistan, Pakistan, and elsewhere, often in fear and distress, refugees and immigrants. As everyone knows, for the second time in 30 years, Afghanistan finds itself in the grip of the Taliban, a ferocious theocratic regime hell-bent on creating its version of an Islamic emirate at great cost to the human rights of its citizens, particularly women and girls, half of the population that it appears to be trying to crush, albeit unsuccessfully, due to their courage and resilience. The Taliban openly treats universal human rights with disdain and as a Western conspiracy, including this week when Human Rights Watch released its annual World Report. In reference to Pakistan's obligations, I'd like to begin by recognizing with appreciation the support the government and people of Pakistan have shown to Afghans over more than 4 decades. Few countries have hosted such large numbers of refugees for such a prolonged period, often with very limited international support and amid their own economic, security, and social challenges. Pakistan opened its borders, schools, hospitals, and communities to Afghans fleeing war, persecution, and instability. That record of hospitality and regional solidarity deserves recognition and respect. However, today we are facing a moment of profound strain, not only for Afghans, but for Pakistan, the wider region, and the international protection system as a whole. From neighboring countries, especially Pakistan and Iran, large numbers of Afghans are returning to their country despite the situation there. In principle, the return of refugees should be a moment of dignity, the end of exile and the beginning of recovery. But returns taking place today are unfolding in a very different manner. According to UN data, more than 2 million Afghans have returned or been forced to return to Afghanistan just last year, including hundreds of thousands from Pakistan alone. Many have returned via deportation or under pressure, especially fear of arrest, rather than through genuinely voluntary and dignified choice. For many families, return has meant renewed replacement rather than a durable solution. This raises serious human rights concerns, particularly the risk of refoulement, the prohibition on returning individuals to situations where they face persecution, torture, or other irreparable harm. This principle is not abstract. It's a safeguard rooted in customary international law and applies regardless of a person's migration or documentation status. Of course, Pakistan has the sovereign right to regulate migration and to enforce its domestic laws. The current framework of returns is grounded in national legislation, including the Foreigners Act of 1946 and the Illegal Foreigners Repatriation Plan of 2023. At the same time, UN and other analyses indicate that the implementation of this framework has raised serious concerns, particularly where distinctions between undocumented migrants and long-standing registered refugees have become blurred and where access to individual assessments and remedies has been limited. I pause to note that while I use the word return, as many of you are well aware, many of the people who are displaced over the border were born and have lived their entire lives in Pakistan. They're educated here, they have businesses here, they've had children here, their social networks here. Some have been uprooted, having never even visited Afghanistan before, and having lost their social and family support in that country. It's important to note that although Pakistan is not a party to the 51 Refugee Convention, it's historically allowed proof of registration card holders issued with UNHCR support to remain and be protected from deportation. Recent reports that registered individuals are also affected by enforcement measures have contributed to fear and uncertainty among Afghan communities and humanitarian actors alike. UN's reporting is clear. Afghanistan is not safe for many people to return to. Women and girls face systematic exclusion from education, employment, freedom of movement, public life. Journalists, human rights defenders, former government officials, ethnic and religious minorities, and others perceived as dissenters face threats, arbitrary detention, and violent reprisals. UNAMA and others have documented cases of torture, ill treatment, and intimidation experienced by individuals after they return. Children are deeply affected. Returns disrupt education, increase exposure to child labor and early marriage, and heighten risks of trafficking and exploitation. International human rights law is clear that decisions affecting children must be guided by their best interests, a principle that becomes difficult to uphold in rapid, large-scale return processes. In that vein, concern arises not only under refugees law, but also under international human rights law. Pakistan is a state party to the International Covenant on Civil and Political Rights and the Convention on Torture. States under these conventions, states must not transfer any individual to another country where there are substantial grounds for believing that they would face a real risk of torture, cruel or inhuman or degrading punishment or other irreparable harm. These obligations are absolute and non-derogable, regardless of migration or documentation status. They're reinforced by Pakistan's obligations under other human rights treaties to which it's a party, including, as I mentioned, the Convention on the Rights of the Child and the Convention on the Elimination of all forms of discrimination against women. UN, NGO, and media reporting has consistently shown that individuals associated with the former Afghan government and security forces, as well as I mentioned, other categories, in particular women and girls, and LGBTI persons, and members of ethnic and religious minorities, face heightened risks of persecution, arbitrary detention, torture, enforced disappearance, and violent reprisals upon return, notwithstanding announced general amnesties. These findings underscore the necessity of an individualized, fair, and effective risk assessment before any return decision is taken, particularly where removal would expose individuals to foreseeable and irreparable human rights harm. And at the same time, Afghanistan is grappling with overlapping crises. Severe food insecurity, prolonged drought, economic collapse, and shrinking civic space have left millions in need of humanitarian assistance. UN agencies and others are responding, but they are doing so with severely constrained resources. For example, UNHCR and ION have made clear that funding shortfalls are limiting their ability to respond effectively. I note that according to recent assessments, more than 17 million people in Afghanistan are acutely food insecure, with an estimated 4.7 million facing the highest levels of hunger. This brings me to a critical point: responsibility sharing. Since 2021, safe pathways for Afghans at risk have increasingly narrowed, leaving many stranded in neighboring countries, including Pakistan, with fewer durable options and prolonged uncertainty. In the United States, the Special Immigrant Visa Program, as well as other refugee referral pathways, have been suspended, effectively closing key routes to protection. In the United Kingdom, Afghan relocation schemes such as ARAP and ACRS are closed to new applicants or referrals and are now largely limited to previous identified cases. In Germany, while earlier humanitarian admission programs provided important protection opportunities, some programs have been ended, and admission for applicants who were invited by Germany to come to Pakistan to have their processing completed at the embassy in Islamabad have been left stranded in Pakistan amid concerns that guest house support may end soon. Some have been deported to Afghanistan, where a couple of weeks ago a guest house was raided by the Taliban, causing particular concerns for women, LGBT plus people, and ethnic and religious minorities. These challenges can't be addressed by a small number of states alone. They reflect a shared international responsibility, grounded in international human rights and refugee law to ensure protection for individuals at real risk of persecution or retaliation. Meeting this responsibility requires renewed collective action and solidarity, including through the reopening and expansion of accessible and effective pathways, and through a willingness by states to demonstrate generosity in offering protection to Afghans at risk. In other words, while Pakistan deserves to be criticized, and in my view, the IFRP should be reversed or brought into line with Pakistan's human rights obligations, it should and must not be expected to carry this burden alone. Protracted displacement is a global challenge, and durable solutions require sustained international engagement. Member states must step up. Let me be clear, support for host countries isn't charity. It's a legal and moral responsibility embedded in the international system. When international support falters, pressures shift to national authorities and protection space narrows with human consequences. In closing, let me return to where I begin. Pakistan's long history of hosting refugees is a source of pride and a demonstration of neighborliness and leadership. Recognizing Pakistan's contribution and also raising human rights concerns are not contradictory acts. They're part of the same commitment to uphold dignity, legality, and shared responsibility in times of uncertainty. That commitment reflects the values championed by Sulema Jahangir, including putting victims and survivors at the center of our concerns. And it is those values that must guide us now. I thank you.
Thank you. The last speaker for the session would be UN Special Rapporteur on the Freedom of Peaceful Assembly and Association, Gina Romero.
Hello, everyone. I hope everybody can hear me, especially at the back. I know it has been a very long morning with a lot of speeches, and now I'm holding you for fulfilling the right of food. So sorry for that, and thanks for staying until now. I am delighted to be here today with you and to honor the legacy of Sulema Jahangir, who, besides being a fearless human rights advocate who fought for advancing justice and democracy, also held different mandates as a special rapporteur. So that is something that is relevant, as Richard also mentioned. Sulema's legacy of activism and resistance is an inspiration of many of us. She bravely stood against autocracy and injustices and emphasized on the importance of strategic activism, judiciary independence, and democratic resilience. In today's critical time, her voice is deeply missed, not only in Pakistan, but then internationally. Today's conference on erosion of fundamental rights and resistance across borders is very pressing. As Sulema said once in the Oslo Freedom Conference, I believe in 2012, she said, when there is less democracy, we need more democracy. While she was reflecting of her struggles of resisting military dictatorship and advancing democracy, of course. And she also said that we realized early on that we have to be as strategic as dictators. And then all those words resonate powerfully today as the world is facing even growing in scope and aggressive attacks on human rights and freedoms. Human rights are under attack by expanding authoritarianism, as it was mentioned before, by securitization and militarization, while there is a severe defunding of the human rights sector and erosions of the principles of human solidarity and cooperation. And states are bringing the national security and sovereign paradigm at the forefront, suppressing fundamental freedoms and those critical of state policies and peaceful exercising the freedoms as threatened as enemies, traitors, foreign agents, terrorists, or national security threats. Despite this, we see remarkable grassroots courage and resistance surging in almost every capital and every city around the world against attacks on democratic freedoms and rights. Young people are at the forefront against social and economic injustice, unfair policies, climate justice, oppression, and genocides. Thousands are paying a heavy price as they encounter excessive force, killings, and arbitrary arrest. And also the spread of technologies used for targeted and mass surveillance is also a serious threat to right to freedoms and has a profound chilling effect. And I will be presenting a report to the Human Rights Council on this very specific topic in June. My mandate is very concerned about the growing global trend of stigmatization and criminalization of civic activism. Especially here in Pakistan, we need to talk about these trends. So the states are increasingly resorting to unjustified and overbroad use of national security and counterterrorism narratives and frameworks to unlawfully criminalize activists, right movements, and ban or violently repress peaceful assemblies, including protests. Judiciary harassment, stigmatization, and criminalization of human rights offenders, including those who provide judiciary support, are also in the target. So human rights lawyers are also human rights offenders. And let me repeat. Human rights lawyers are also human rights offenders. Colleagues and I have expressed this week our alarm for the conviction of lawyers and human rights offenders Iman Masari Hasir and Hadi Ali Shatta, with charges of cyber terrorism after doing some post and repost on X. It's in an extremely fast process. They each received multiple concurrent sentences of imprisonment, totally 17 years, and a very millionaire fine. And I want to echo one person who spoke in the first panel when he was saying that criticism of a state is not a hostility of the state. And this is something that needs to be kind of imprinted in every person that is here, because it needs to be ensured here in Pakistan. Deeply concerning also is the continued trial of activists in military courts and anti-terrorism courts, and charging and sentencing them in this sedition of terrorism charges for their peaceful activism. And let me be very clear. Terrorism is actually a very pressing, real challenge. But it is very important to fight against terrorism without creating new victims of the anti-terrorism fight. And then civil society, human rights offenders, and human rights lawyers sometimes are the victims of this anti-terrorism fight, and we need to stop this. Civilians should not be tried in military courts as they lack fair trial and due process protections. Colleague Anas and I have called for the immediate and unconditional release of activists unlawfully imprisoned from the exercise of their fundamental freedoms, such as Idris Katran, who is currently serving 14 years of unjust imprisonment. We are also raised concern about the arbitrary detention, enforced disappearance, and mistreatment of Baloch ethnic rights activists, such as Ms. Bahram Baloch, arrested during a peaceful sit-in last year. And then also, we have also been reporting about even extrajudicial killings of journalists and human rights offenders in the Baloch area. Colleagues and I also have been writing to Pakistan concerning the recent amendments of the Anti-Terrorism Act in August last year, as well as similar legislation enacted in Balochistan and Punjab provinces. These provisions risk violating, among others, the rights, the human rights, including the prohibition of arbitrary detention, enforced disappearance, torture, and cruel, inhuman, and degrading treatment, and others. And despite all these challenges that you know perhaps better than me, and we special rapporteurs have tried to have a constant interaction with the governments. So for those of you that don't know how we work, we have mainly three methods of work. We do visits, we do letters to governments and other type of communications, and we do reports. But in the last 5 years, we have sent over 50 letters to the government with human rights allegations, and we got only 8 responses. This means that 85% of the letters didn't receive any reply, not even an acknowledgement reply. Does this sound as a commitment with human rights? I'm not pretty sure about that. Besides, our visits are not accepted. It has been more than 10 years since the Special Rapporteur came on an official visit, for the information that I have. Right now, there are around 25 requests of visits pending. I actually requested a visit in 2024 that I re-insisted last year. Ministry Aslam is here. Perhaps we can also talk about this, the possibility of special rapporteurs to come and visit the countries. And I really hope that all the ambassadors and the international community present today can also help us to request and to push for those visits and those replies. Although the conference agenda covers a variety of issues, they are very relevant and linked to freedom of assembly and of association rights, which are the rights that are in my mandate, such as the right of fair trial, the protection of activists and human rights defenders. I encourage you all to take freedom of assembly and of association concerns also into consideration during the deliberation of these 2 days. Protecting and enabling freedom of assembly and of association rights are also essential for advancing conflict resolution, climate justice, and remember, this is also an assembly. And these rights allow us to come together to advance other rights, freedoms, democracy, and rule of law. And these type of assemblies are as important as the small private assemblies from civil society organizations as a massive protest. And all then need to be respected equally. Freedom of assembly and association rights are integral to human dignity. They are important enabling rights. And then when freedom of assembly and of association rights are unduly restricted, all other rights are affected. As the audience here include lawyers, parliamentarians, and the diplomatic community, I want to continue. Support for ensuring freedom of assembly and of association rights are discussed and then protected, so together we can resist the erosion of rights and freedoms globally. To end, I want to address an important last point, is that some human rights defenders, some civil society representatives, some activists should be here today with us, but they can't. They have been persecuted, jailed, silenced, and some of the activists present in the room are also afraid they could be the next. And yet they tirelessly keep working for rights day after day. And I want to thank you all, because your courage, resistance, perseverance, and hard, selfless work are a source of inspiration to all us and to me for my work. So thank you for everything you do.
Thank you. And with this, we come to a close of our morning session. I am very grateful. We are very grateful for your attention and for your patience. Thank you.